Okay, another couple of people have now also dialed in, so I think we can start now. So again, good morning, good afternoon, good evening to everyone here participating. We are very, very happy to have so many attendees, not only from Europe, but also obviously from Asia, to our today's webinar, Counsel Fees and Arbitration Reforms and Challenges. This event here is today jointly organized by two young arbitration groups. And if I say young, it's a little bit relative. Some of us are around 40, so we are still young at heart, let's put it that way. And these two young arbitration groups are ASAb40 and HK45. I myself, my name is Patrice Gaillet, and I'm one of the three co-chairs of ASAb40, jointly with my two colleagues, Daniel Durante and Flavio Peter. As we can see, we also have some younger colleagues here today, so let me say just one or two sentences about these two arbitration groups. HK45 is the young arbitration group of HKIAC, the Hong Kong International Arbitration Center, and ASAb40 is the young practitioners group of the Swiss Arbitration Association. And already the two names indicate that there are different age limits. So if you want to join HK45, you have a little bit of longer time, so until the age of 45. With ASAb40, as we are a little bit stricter, so if you are under 40, you can join. And membership is free, so just go on our web pages and enter your name, and we are happy to have you on board. So what are we going to discuss today? Counsel fees. Well, obviously, when we discussed this topic also with our co-chairs from HK45, it was a little bit the discussion, well, it could be a little bit dry issue, a little bit too technical. But at the end of the day, it is one of the most important topics because it might be very decisive at the end of the day what kind of law firm a party chooses. And fee and fee structures might be one of the most important factors that come in. And in order to discuss these fees and fee structures, we are very happy and fortunate to have excellent speakers today, which bring from very different angles the different policies and considerations that need to be considered. I will start, and very happy to start with Raymond Go. He will represent our in-house perspective. He is currently General Counsel of the China Tourism Group, but before that he was also in-house counsel at the Bank Insurance Group and also with the Barclays Investment Bank. So welcome, Raymond. Then second, I'm very happy to welcome Brianna Young. She's a professional support consultant and practice manager at Herbert Smith Freehills in Hong Kong. But apart from that, we are also very happy to have her on board today because Brianna is one of the co-chairs of the Hong Kong Law Reform Commission subcommittee, which deals with outcome-related fee structures for arbitration. So welcome also to you, Brianna. Then, of course, the speaker panel would not be complete if we didn't have also the perspective from third-party funders. So we are very happy to have also Jörn Eschmond on board. Jörn is the Senior Vice President at Burford Capital, and he is responsible for the litigation finance work in Europe and Asia. And before joining Burford, he practiced also international arbitration, not only in Hong Kong, but also in Zurich. So welcome also to you, Jörn. And of course, last but not least, we need, of course, the counsel perspective, and this will be dealt with by Tom Pressler. Tom is a partner in the International Arbitration Group of CMS. He is based in Germany, but before having been based in Germany and in Berlin, to be precise, he worked also with CMS in Hong Kong, and before the pandemic divided his time quite equally between Hong Kong and Berlin. So welcome to all you, and of course, then I would hand over directly to Kitty Zhang. She will be the moderator of the first panel, and the floor is all yours.
Thank you very much, Patrice. So as Patrice mentioned, in the first half of today's panel, we'll be discussing outcome-related fee structures, which is indeed a very timely topic, given that the Hong Kong Law Reform Commission subcommittee on this very subject just published a report last month with its 14 final recommendations. And in fact, just yesterday, the Singapore Parliament also passed a bill to allow conditional fee arrangements, although not damage-based agreements. So before we delve into the substance of these recommendations, I want to start with the basics and ask Brianna, what exactly do we mean when we talk about outcome-related fee structures? And what is the difference between these conditional fees and damage-based agreements?
Thanks, Kitty. Outcome-related fee structures is essentially an umbrella term that I have to confess we made up to cover any form of fee structure between a client and its lawyer, where the client agrees to pay any part of the legal fees contingent on success in the case. The reason we came up with a new term is that there's so many different bits of terminology in different jurisdictions, but in essence, we're talking here about three types of what we can broadly refer to as outcome-related fees or success fees: conditional fee agreements, damages-based agreements, and hybrid damages-based agreements. So conditional fee agreements, sometimes just known as CFAs, I'm sure you're all familiar with. That's the arrangement where the client either pays no fee during the life of the matter and then pays the full fee plus an uplift if the case succeeds at the end of the case. An alternative is where the client pays a discounted fee during the life of the matter and then makes it up to the full fee plus the uplift if the case succeeds. And those are sometimes called either no win, no fee arrangements or no win, low fee arrangements. So for our purposes, that's a conditional fee agreement. A damages-based agreement, many of you may know rather as a contingency fee. And that's essentially where the client pays nothing during the life of the matter. But if the client succeeds, it will make a lump sum payment to its lawyer. The arrangement we're most familiar with in that context is where the lawyer gets a percentage of any damages awarded. But in Hong Kong, at least, we've proposed that there can be other forms of damages-based agreement payment. So that's a DBA. And then the hybrid DBA, as you would imagine, is a mixture of the first two. The client would normally pay a low or a discounted fee as the matter progresses, plus a damages-based payment on success. So you might get a client paying 50% of the lawyer's hourly rate during the life of the matter, plus say 30% of any damages if the client succeeds. And it's important to emphasize that, at least for Hong Kong purposes, success is not just an award of damages, it's whatever the client and the lawyer agree counts as success, and that's done deliberately to make sure that these kinds of fees would be available to the broadest range of clients. So I hope that's a helpful overview as to what the three broad types of fees under the outcome-related fee bucket are.
Thanks very much. So if I'm understanding it correctly, is it correct to say the fundamental difference, if you can say, between CFA and DBA is that CFA is not dependent on the award that is granted at the end, whereas the DBA will be related to whatever the financial outcome of the cases?
I think all types of outcome-related fees are ultimately dependent on the award, on whether the client succeeds in its claim or its case. The difference really is on the way the lawyer takes payment of the success-related fee. So in a CFA, the success element is usually an uplift on the lawyer's normal rates. So we tend to refer to the lawyer's usual rate as its benchmark rate. So say that's $100 an hour. then in a CFA, the client would normally negotiate that it would pay, say, no hourly rate during the life of the matter. But if it succeeds at the end of the case, it would pay the full time cost, but uplifted to say 120% of the normal hourly rate. So say $120 an hour. So at the end of the day, the client pays more than it would have done on a normal arrangement, but it only pays that uplift if it gets a successful award. With a damages-based agreement, again, the client only pays the success bit of the fee, or only pays at all if it wins, so still dependent on the award, but the type of fee is not usually an uplift on the lawyer's hourly rate. It's either a percentage of the damages awarded or of any other financial benefit that the client obtains. So we'll look at this in a bit later, but that's intended to cover, acting for a respondent where you save the respondent money by getting an award for less than claimed, for example.
Yeah, that's very helpful. Thank you. And of course, I want to mention here there are other alternative fee arrangements that are not dependent on the outcome of the case, such as cap fees, which is oftentimes used. And this will be discussed in the second half of today's panel. So now that we're all on the same page on the definitions, my next question is why we should care about the CFAs and DBAs. And since we're very lucky to have such a diverse panel, I want to perhaps ask each panelist to use one sentence to summarize what is the significance of this subject. And Brianna, if I can start with you again, perhaps from a policy making or policy recommending perspective, what does this mean for jurisdictions serving as arbitral seats?
In a word, I think it's to maintain competitive advantage. There's very clear demand from clients for these fees. And if a seat isn't able to offer them, then the clients will go elsewhere.
Thank you. And since you mentioned the client side, Raymond, is it true that from the client side, the availability of such fee structure is something that is valuable?
It is extremely valuable, especially for clients who have a very strong case, but they are not able to put up the counsel's fees in a lump sum at the very beginning. So it allows them to sort of manage their cash flow a little bit better. Thank you.
Thank you. And then Tom, from the counsel's perspective, how might this impact your business?
Well, putting it that way, I work in two jurisdictions where this is not possible right now. So both Germany and Hong Kong don't actually allow it, but it nevertheless is very often requested by clients. And of course, there's certain ways to structure things which might end up with also making it possible for clients to nevertheless pursue their case. But I completely agree with Raymond. It's necessary in certain situations for clients which have a strong case but just don't have the finances. And that might also turn over to Jan, because that's of course the other option, going to a financer then.
Yes, Jan, how about from the third-party founder side? Is this reform welcomed?
Yeah, I think we generally welcome this development. We're of course happy to finance matters in success fee and non-success fee jurisdictions alike. That's not the question, but where success fees are permissible, it's of course great to have everyone's interest in a successful outcome aligned. In other words, client, funder, and counsel all have skin in the game, so to say. So we're not really concerned about more competition from law firms. We're actually welcome it as an opportunity here to partner also with law firms potentially to who have fees at risk to potentially share in that risk on a portfolio basis. So there are all sorts of opportunities, and I think they outweigh the disadvantages.
Thank you.
Can I mention one more thing very quickly? I absolutely agree with Raymond and Tom that this is a vital option for clients who can't afford to fund a strong claim, but we're seeing more and more that it's not just impecunious clients who want these type of arrangements. Many totally solvent corporates want this kind of arrangement to defray the very significant cost risk of arbitrating. They want the cost off their books, and as Jorn says, they want their lawyers to have skin in the game, to share that risk with them. So I think it's important to say at the outset that this covers more than just the impecunious clients. Although we
see exactly the same thing, Brianna. We see exactly the same thing. It's not only about impecunious; it's also about, as you say, corporates who are actually, trying to manage risk and manage costs, and use us or maybe success fee arrangements to that end. Yeah.
Yeah. Thank you very much for the important note. Although this panel seems very much welcome outcome-related fees, the permissibility of such fees has historically at least been a controversial subject, with some jurisdictions like the United States has been embracing it for many, many years, while other jurisdictions, which includes the current laws in Hong Kong, still prohibiting it. But of course, things may be about to change very soon here with the latest recommendations by the Law Reform Commission subcommittee. So Brianna, for the benefits of the all audience who may not have read the report, could you just give us a short highlights, the editor's cut of the subcommittee's recommendations, and in particular, if these recommendations were adopted, how would they compare with the rules with other jurisdictions that also allow certain forms of outcome-related fees?
So I think just on the controversy, you're absolutely right to say that, in many key arbitral seats, it's a non-issue now, but there are lingering concerns in Hong Kong and Singapore that lawyers who have a stake in the financial outcome of a case are essentially in a conflict position. And there are very old historical reasons for that. We are pretty confident that those reasons are mostly irrelevant these days, particularly in arbitration, because the vast majority of clients who arbitrate are commercial parties, and they're sophisticated ones at that. But there is a bit of that lingering suspicion, and that's something that we have had to address in considering the types of reforms to suggest. In a nutshell, people were concerned about ambulance chasing of the kind that you see in the US, where lawyers are chasing after clients to pursue claims just so the lawyer gets a cut. Obviously we'd say that access to justice and more options for clients outweigh that, and also that with appropriate regulation, you can address any concerns that remain. So in terms of the recommendations that we've made, as everyone will have gathered, the basic recommendation is that the law in Hong Kong be changed to allow outcome-related fees of the type I explained at the beginning. It is really important to emphasize that the proposed changes would only apply to arbitration and to court proceedings in Hong Kong that relate to arbitration, like an application to enforce the award. They do not apply to civil litigation proceedings in Hong Kong, and certainly no criminal proceedings. So this is limited to arbitration, and that's really essential. As well as applying to Hong Kong seated arbitrations, they would apply to arbitrations where the client instructs a Hong Kong based or Hong Kong qualified lawyer, but the seat is outside Hong Kong. And that really just reflects the international nature of Hong Kong. We would recommend all three forms of fees: the conditional fee, damages-based agreements, and the hybrid. And we have recommended that to the extent those fees come in, there are caps on the success fees that a lawyer can charge. They're quite generous caps, but they are still caps, and we think that's an important way to prevent abuse of this type of fee. The proposals are that Hong Kong would amend its arbitration ordinance and its legal practitioners ordinance, both of which currently prevent lawyers from charging any kind of success fee for any type of contentious matter, and that includes arbitration. So we would need those two laws to change. We'd also need the Law Society Code of Conduct for Hong Kong solicitors and the Hong Kong Bar Association Code of Conduct to change to allow these types of fees, because at root, the objections to success fees are ethical objections about the way lawyers interact with their clients. And ultimately, all of these fee arrangements are arrangements purely between a lawyer and that lawyer's client. And so an important feature of our recommendations is that the other side, any party that loses against a client with a success fee in place, isn't penalized by the fact that that success fee is in place, so that any additional fee that the client agrees to pay to its lawyer on success can't be recovered from the unsuccessful party. And we think that's a really important pillar of these recommendations, to ensure that they work effectively, that they're not abused, and also that they don't generate a whole load of satellite litigation, which is what tends to happen if the losing party is then ordered to pay a big additional fee just because its opponent happens to have agreed a success fee with the lawyers. I'm conscious that's a lot of information. Does that broadly answer your question, Kitty?
Yes, and I think we will talk more about some of these caps and safeguards that you mentioned in a moment. But before I do, I want to ask you, what about the position in Switzerland? Would the Swiss courts or legislature agree with the subcommittee's rationales?
Well, I mean, Swiss law is relatively restrictive in terms of the options for lawyers to agree success fees. We have the Swiss Federal Lawyers Act, which prohibits certainly full success fee arrangements. So for Swiss courts, these are all arrangements where the lawyer's remuneration is only owed if the case is successful, or where their only remuneration consists in a share of the proceeds. In other words, pure contingency fees are inadmissible. Why is that? Basically, what Brianna said before, concerns about lawyers taking advantage of their unsophisticated clients, so to say, in terms of being able to assess the prospects of a case. Concerns around the independence of lawyers who have a vested personal interest in the outcome of a dispute. All those are kind of interrelated. These concerns, they have to do with the dual function that lawyers perform as representatives of of their clients. But also as, for lack of a better word, maybe officers of the court who serve the law and perform an important role in the judicial decision-making process. Now, while pure contingency fees are inadmissible, the Swiss Supreme Court has repeatedly accepted what we call a pactum de palmario, which is essentially an arrangement where the client pays a reduced hourly fee, flat or hourly indeed, a base fee, and the lawyer is then in turn for that reduction entitled to a share of the proceeds as an additional contingent fee on success. There are a couple of benchmarks around this. So the fixed fee must at least cover the lawyer's costs and allow for reasonable profit, and the contingent component must not be higher than the reduced base fee. And importantly, this pactum de palmario arrangement can only be agreed at the outset of the mandate or after the dispute has resolved, but not in between. So that's, I think, the short answer. Generally speaking, I think in terms of how it's been received and what the positions within the legal community are, I think you find all sorts of positions on the extreme ends. You have those who like the status quo, who might even call for additional restrictions. More people asking for more flexibility. So all sorts of things. I think the general majority, I mean, it's just a sense. I think Swiss legal community generally is quite okay with the status quo. It's different in the arbitration community, especially the younger generation. So my sense there is that those in favor of liberalizing it to some extent gain traction and might already be in the majority. As an example, in 2017 there was a Swiss court decision that basically confirmed this relatively restrictive approach to success fees, and that decision received very harsh criticism, especially from the arbitration community, because it made it harder for them to compete with some of their international colleagues.
I also wanted to ask, would the court deal with it differently if it's an international arbitration case? For example, if it's an enforcement of award of an international arbitration award, is there different treatments, or is basically treated the same as the domestic laws?
Well, the angle is different. So if you come across these cases in set-aside applications, for instance, so is it different? Yes and no, I think. So one example is a more recent one in 2018. The Supreme Court had to decide an application to set aside an award on public policy grounds. In a nutshell, what happened was that a company had retained a Swiss law firm to act in an ICC arbitration. They had engagement letters and they're provided for reduced hourly rate plus a certain success fee, and then subsequently a dispute about the fee payments arose. And in that particular case, that was referred to arbitration as well, and the sole arbitrator deviated from the Supreme Court case law, so that the company ultimately challenged that award on the remuneration case. The Swiss Supreme Court then upheld this award, saying, "Look, fine, the sole arbitrator, you deviated from our existing case law, but neither the mismatch between the outcome related and the fixed portion of the fee or the conflict of interest was enough to justify setting aside the award on public policy grounds." So it's a bit of a, it might come at first sight as a bit of a surprise, because the arrangement in question would have almost certainly been invalid as a matter of Swiss law. So that's in a way, but in itself, it wasn't sufficient ground to justify setting aside the award. So that's kind of the yes part of my answer. The no part is that ultimately from a Swiss lawyer's perspective, not much has changed because of that decision. Success fees are still limited, restricted, as I just outlined before. So from a Swiss practitioner's perspective, for normal cases, nothing really has changed. Maybe on a practical note, in the end, if you're sitting as an arbitrator, like in this particular case, it seems generally wise to align your approach to success fees with, the existing case law of the Swiss Supreme Court here, just to ensure, foreseeability of the arbitral process and also compatibility of Swiss arbitral awards with Swiss case law. I don't think it helps anyone if there are double standards on that.
Thank you very much, Jörn. And Tom, what about the rules in Germany, where you are?
Well, it's a rather easy answer. It's generally simply not allowed. So you're not allowed to have success fees in Germany. We'll discuss a bit about other options which might take some of the interest into account on the second panel. Of course, one always has to have a look at how that is then actually handled in practice. I can't guarantee that there aren't success fees actually agreed between lawyers and parties in Germany, looking at the consequences. While they are rather dire, I believe, in some other jurisdictions, in Germany that's actually not the case. So looking at decisions of the courts, if they sanctioned lawyers for not abiding by that rule, it was actually minor payments which were dealt out for that. So it's a bit of a grey area in a certain degree. First of all, are there certain arrangements you can do which aren't actually success fees, so which would be still possible, even taking into account certain deferral of payments? And then secondly, if a lawyer does it, will that actually be of such a consequence to the lawyer that it is a real deterrent? Of course, as big law firms, you always have a legality principle and you don't want the scandal, but smaller law firms might not be as much looking at their general reputation, and they might take on the idea that one can make good business of it and simply take the risk. So it's a bit of an interesting area, and actually the discussion in Germany is not as developed as it is in a lot of other jurisdictions, which I always find quite interesting. Of course, there are discussions about it, but I think a lot of lawyers in Germany are actually quite content with the situation as it is right now.
That's interesting. It does seem like among the different type of outcome contingency fees, at least, perhaps the most controversial type is the contingency fee, the damage-based arrangements. Some jurisdictions, as you mentioned, like Switzerland, the new amendments in Singapore, while they permit some form of CFAs, the pure DBA form is not allowed. But as Brianna mentioned, this is recommended to be allowed in Hong Kong. So Brianna, I'm interested to know how did the subcommittee arrive at the recommendation that DBAs and also including hybrid DBAs should be permitted in Hong Kong?
Well, our broad thinking, we sat down and looked at it at the threshold level, and we thought, well, if you're going to permit one sort of success fee, we couldn't see a policy reason why CFAs were less objectionable than DBAs. And there was a bit that sat behind that. Ultimately, our consultation was limited to arbitration. And as I said earlier, we are very confident that the vast majority of parties who arbitrate are either corporates, or if they are individuals, they're quite sophisticated individuals. And because of the requirement for specialist counsel, normally they will be well advised. So point being, we think most people involved in this are going to be sophisticated. Hong Kong generally is a free market economy, and we just felt that clients should be able to negotiate the fee arrangement that works best for them and their lawyers. So we put that into the consultation and we asked people to respond. And of all the people who responded on DBAs, there was only one respondent who objected to them. There was very vocal support for DBAs and hybrid DBAs, as well as conditional fee agreements. And it was really around that maximum flexibility point. You don't have to agree a damages-based agreement with your lawyer, but you can, if that's the only way you can pursue a claim. Like if you really can't afford to pay the lawyer as you go along, then many clients are more than willing to share their damages with their lawyers. The other aspect was two aspects. This point about clients wanting their lawyers to share in the risk. Many clients really find that an advantage. They feel that it really enhances the way the lawyers conduct the case. And it's up to the client to decide how they value that work. And I think, we've all learned a lot about how clients, including clients who are entirely solvent, value those claims. The other issue, of course, is that Hong Kong now allows third-party funding. And basically, if a client enters into a funding arrangement with a funder like Burford, then that is essentially in return for the funder taking a share of the damages. So it's basically a DBA, and we couldn't see any policy reason why that should be allowed between a client and a funder and not between a client and its lawyer. There is a cap on the DBA payment. The cap we've recommended is 50% of the financial benefit, the award or other financial benefit that the client obtains in the case. But within that, we think clients should be free to negotiate, and we don't think there are any really strong objections that persuaded us otherwise.
Thank you. And before I circle back on the caps point, I want to ask Raymond, from the client's perspective, how do the companies perceive fee structures in which part or all of the counsel fees are conditional on a favorable outcome? Do you agree that it better aligns counsel's interest with the clients, or would you be more wary of the advice given by the contingency fee counsel?
Thanks, Kitty. I really think it depends on a few factors, such as the nature of the client, the dispute in question, as well as the quantum. So if we look at, for example, say a typical investment, voucher investment bank where I was previously in, the CEO and the chairman of the board would generally not be very receptive to these alternative arrangements, because they believe that this is the established norm. In England, this is what you do. You pay a certain amount, and what if you win and you end up paying an additional 20–30%? They would have a difficult time explaining it to London or New York why there's this additional expense. But on the other hand, in my previous role with another big Chinese company, it was pretty interesting because the chairman and the CEO, he actually wanted to go up to, as Brianna has mentioned, up to 50% of the recovery, because it was a very significant dispute. It's about $700 million, which we won eventually. And he wanted the lawyers to have skin in the game, and he felt that being a founder, he felt that why should he take on all the risk? If the lawyers can share in it, they'd be more incentivized and more motivated to come up with all sorts of legitimate, avenues. And from what I've seen, it does work. The law firm in question was very, very motivated and came up very responsive, came up with a lot of very good ideas. So I think it really depends on and maybe if I can just take one more minute. At the other extreme, you have, I've noticed as well in my current role, you have certain new law firms who are emerging. And as Brianna has mentioned, they sort of do ambulance chasing. When they suspect you have a dispute, they come up to the chairman and they come up to you and says, if we don't win, you don't have to pay anything. But as general counsel, you tend to take a very skeptical view, because it's not just about winning this dispute. It's about, if you pursue the dispute, what is the reputational cost to your firm, assuming it leaks? It takes up a lot of management time, a lot of administrative time. Is it really worth it? So I think there's a lot of moving pieces that we have to take into account very carefully.
That's very important.
May I maybe add one point on what I just missed on my previous answer, which Brianna reminded me of. There's of course one exception under German law which does allow success fees, and that is if you end up with a client who's not able to pursue their claim, and that's exactly what Raymond and I talked about before. But there's a situation where it's very important to actually have the possibility of success fees. That is, if the client would otherwise not be able to pursue a decent claim, then there's certain possibilities where you will end up being able to get that. The problem is, as a big corporate law firm, a lot of your clients will not fall under that exception, and then you end up with this absolute prevention of doing it and the grey area. However, if the client otherwise could not pursue, and then there's certain safeguards which are quite similar actually to those which Johan just mentioned, it may be possible, and it is possible under German law, to actually end up with a success fee for a claim.
Thanks very much, Raymond and Tom. Before I go on my next question, I just want to remind all the participants and the audience members that we do have a Q&A function. So if you have any questions, feel free to type them in and we'll ask them when it's relevant. So I want to ask next about the caps on success fees and DBA payments, which, as Brianna mentioned, is 100% for success fees and 50% for the DBA payment. And Brianna, could you just tell us a little bit more about the subcommittee's considerations in setting these specific caps? And in particular, I think in the consultation paper, which was published in December 2020, the subcommittee was considering a cap potentially less than 100% for success fees, and in the range of 30 to 50% for the DBA payment. What changed the subcommittee's view and made it decide to adopt the higher end in both models? You are on mute, Brianna.
Sorry. The short answer to that is it was the public's response to the consultation. We had overwhelming support for capping the fees, but also overwhelming support for quite a high cap. And of the respondents who responded specifically, we are invited. We just said this is the range we're looking at. We invite responses on the appropriate number for the cap, and the vast majority on CFAs came out that 100% was the appropriate cap. It does follow the recommendation in England and Wales on success fee caps, which was made by made in the context of a 2019 consultation led by Rachel Mulleron and Mr. Bacon, both of whom are experts on this. So it's been well considered. On DBAs, again, it was our view that we wanted to give clients maximum flexibility to negotiate the deal that they felt was appropriate, while still imposing reasonable safeguards so that clients couldn't be completely ripped off by their lawyers. And then again, it was respondent views. The other thing I can't emphasize enough is these numbers are caps. It is not going to be the case that every single success fee provides for the lawyer to get 100% uplift on its fees or 50% of the damages awarded. I would say, to be honest, that that's going to be the exception. It's a negotiation, and very few people are going to start at the high end in a negotiation. So that's how our thinking progressed, and that's how we ended up with the higher end caps, but we still think they're reasonable in the global context of these fees, and that they allow parties the flexibility they need while keeping them safe within the regime.
And in addition to the caps, I think another recommendation, which probably aims more to protect the losing party, is the recoverability of success fees and the DBA payment. Could you tell us also in the plainest terms, how would the recommendations operate in situations, say, where there's a CFA or DBA in place and the party succeeds in a claim? Then what can this party realistically recover from the losing side in terms of legal costs?
Okay. So the basic principles we operated on are that a losing party shouldn't be penalized in costs simply for the fact that its successful opponent happens to have agreed some form of success fee with its own lawyers. That just seems to us fundamentally unfair. And in addition to that, we looked at other jurisdictions which have historically allowed the winning party to claim from the losing party the success element of its legal fees. And what seems clear is that where you allow that, what happens is that the losing party understandably objects to paying that additional cost, and it leads to quite a lot of satellite litigation where the losing party challenges the effectiveness or the legality of the winning party's success fee arrangement, and that's in an attempt to either delay or avoid paying the success fee element of the winning party's costs. So, this is all against the background that in international arbitration, we think the norm is that the tribunal will order the losing party to pay the successful party's legal costs. And, as we all know, that's not usually 100% of their costs. It'll be a reasonable proportion. So where we came out was that a losing party should only ever have to pay the other side's recoverable costs on, if you like, the normal basis. The success fee fact shouldn't enter the calculation of recoverable costs at all.
And since you mentioned in international arbitration, the tribunal usually have broad discretion in apportioning the legal cost. I think if we compare the final recommendations with the consultation paper, it seems like the subcommittee eventually decided to broaden the recommendation and left the door open for tribunals to order payment of success fees or DBA payment in exceptional circumstances.
Yes, and again, that was just really in keeping with the overarching view that this should be as flexible as it can safely be. We did leave the door open for exceptional circumstances. And by that, in our view, that really does need to be a high bar. It needs to be an exceptional case. The leading example was a relatively recent English court case where the losing party was ordered to pay essentially success costs because the court found that it had deliberately driven the claimant into bankruptcy, which meant that the only way the claimant could afford to bring the claim was by obtaining third-party funding. And so that's the kind of exceptional circumstance we have in mind. But we didn't think it was fair to shut the door altogether.
Yeah, but just to take it even one step further, why set a policy at all? Why not just leave it entirely to the tribunal's discretion, just based on the normal reasonableness determination?
For the reasons I described earlier, we fundamentally, as a policy matter, don't feel that it's fair for a losing party to be penalised simply because it happens to be arbitrating against a party that's agreed a success fee. That's nothing it has any control over. And also, we did see particularly England and Wales, which used to allow recoverability of success fees, that it led to the satellite litigation I described earlier. And that's not what anybody wants. It prolongs ultimate payment of the costs order. It costs more money, and it's just not to anybody's advantage.
I see. I want to turn to Yuan to ask if how does this play in line with the third-party funding regime. I think, do litigation funders often charge a success or risk premium as well if the claim is successful? And would those be recoverable usually?
Yeah, I mean, the recoverability of these, of our return on our investment that regularly arises in cases involving third-party funding. Some of you might know that I think the International Council for Commercial Arbitration and Queen Mary University set up a working group a while ago, and they specifically looked into this question, and said ultimately it will depend on the definition of what the recoverable costs are under the applicable law and or on the procedural rules. But generally speaking, according to that particular report, the assessment of reasonableness and the disclosure of funding costs at the commencement or during the arbitration is critically important, so that the other party knows about the overall position. The ICC looked into recoverability of funding costs as well in its report on cost decisions, and in conclusion, again, I think was similar. There may be circumstances where it would be reasonable for the successful funded party to recover the costs of funding. There's a bit of case law on that as well. In 2016, there was the ASAb v. Northcott award, which was upheld by an English court, London-seated ICC arbitration, where a tribunal considered it was within its general discretion to award these costs, about £2 million, I think, in funding costs in that particular instance. And following this ASAb case, there have been other claims for recovery of funding costs, and they've, it seems they are becoming increasingly common and accepted. And tribunals sitting under different arbitral rules, national laws, have also held that they have the power to award such costs. Most recently, there were, I think, at least 2 SIAC awards in Singapore-seated arbitrations, awarding those costs under, I think it's Rule 37. And I think just a few weeks ago, in November 21, there was another High Court decision in the UK in the matter of 10K v. Katanga. Again, $1.7 million in funding costs, which which were upheld by the High Court. Maybe another very brief comment. We do a lot of, for instance, ATE, after the event insurance business. That's essentially an insurance you can take out for the funded party to make sure it's covered in case it loses, and it has to pick up adverse costs. Even those costs, there are awards saying those costs, these types of premiums you have to pay for such an insurance, are an integral and necessary component of the funding costs, and are as such recoverable as well. I think it's still a bit of kind of uncharted territory. It's still kind of even 5 years after the SR decision, but there is a growing body of helpful case law, and funded parties might be encouraged by this to try and seek recovery of their funding costs in future cases. And I mean, maybe as a last sentence, I think tribunals as well are increasingly cognizant of the issue, and of their discretion to award those types of funding-related costs.
Yeah, thank you. And so it sounds like with recoverability may be treated differently by different tribunals in different jurisdictions, and also with the possible options in the near future for different fee arrangement, both with legal counsel and with the third-party funding regime. Do you think is there scope for third-party funders to work together with law firms who have such fee structures in place to share some of the risk or achieve even more benefits for the clients?
Yeah, I think there's absolutely room for that. I mean, the introduction of these ORFS will provide parties essentially with another option for funding their arbitrations in Hong Kong in particular now, since we're talking about that, especially in circumstances where their case may not meet the requisite criteria for the parties to avail themselves of third-party funding. It will also, I think, further, provide further opportunities for law firms to work with funders to manage the significant costs and risks that are associated with, taking risk on your fees. Law firms are generally, as we all know, cash in, cash out partnership models, and then they don't have access, generally speaking, to outside equity or debt. So that means they cannot take on too much risk, and then even the most successful contingency law firms, they all have an upper limit of risk tolerance, so to say. So funders can share that risk and the costs associated with these contingency arrangements by partnering with law firms to provide capital, on a single case basis, on a portfolio case basis, and law firms can leverage such portfolios for growth, to win new business, to expand, develop practice areas, or to grow geographically. So obviously, Burford has a long history in the US where contingency fees are accepted. So we pioneered a lot of those law firm portfolio arrangements, and that's certainly an opportunity we see. Maybe in a different intensity and with different specifics in other success fee jurisdictions as well.
Thank you. That's so great to hear. And of course, there are other policies proposed by the subcommittee, including certain safeguards like a cooling off periods when a party enters into such a fee agreement, how to deal with termination, and also disclosure requirements, which we don't have the time today to discuss all of them. But I do encourage the people who are interested to find the answers in the subcommittee's report. And I just want to ask one question from the audience about the different economic models for solicitors firm and barristers, in particularly their ability to invest in the outcome of the arbitration.
Yes, we gave that a lot of consideration. And if you look at the report, I haven't brought it out particularly today, but there's quite a lot of consideration of the position of barristers separately. Yes, we are very conscious that this is something that's not easy for barristers in Hong Kong because of the way they hold money, the way they're able to receive money. So, but at the end of the day, we are working with a split profession, and there is a lot of scope for the client, the barrister, and the solicitor working together to negotiate a fee that works for all of them. There is no obligation for the barrister to accept a success fee simply because the solicitor is accepting a success fee, or vice versa. So yes, I mean, it is something that we gave careful consideration to, and we had a lot of discussion and response from the Bar Association to make us aware of the particular situation for barristers.
Thank you very much, Brianna. And with that, I want to thank all the panelists for a very insightful discussion on the first topic, which is the outcome-related fees. And I'm sure we're all very excited to see what will become the new rules in Hong Kong in the near future. And who knows, maybe there will be changes in Switzerland and Germany down the road as well. And I will now hand it over to Leonard to lead the discussion, which is on an even more important topic related to counsel fees. Leonard, you have the floor.
Thank you very much, Kitty. Well, first of all, I'm sorry if something is obviously wrong with my camera. It's not that I'm trying to find my veins to shoot some heroin, and I apologize for that. We discussed the questions of the success fee. Now, this is one aspect which one can take into account, but there are other types of structure fees, and I was wondering which one you had come across, be it in terms of flat fees, discounts, caps for specific stages, partial deferred payment, sharing of work with in-house counsels, for example. So can you enlighten us? Maybe Tom, you go first.
Of course, happy to do so. Well, looking at the ones which you've stated here, flat fees, we do come across that, especially if it's for something where one can really sort of have a part of the work which is limited, which one can calculate with a flat fee. For instance, a demand letter, an initial assessment of a case. For those kinds of things, we have seen flat fees. It would also be possible, and I think that's something which we might address a bit more and more questions for a certain very short type of proceeding. However, it's of course something which puts also a certain risk on the client, because they might end up paying more than they would have paid under the hourly rates. And that's why I in my experience, think that clients often like caps more than they do flat fees, because that actually puts the risk on the law firm. So if you run over the cap, then that's your problem as a firm. While if you go under, the client actually gets the benefit of that. So that's again in similar situations something which we see, and which actually also something which clients do demand. Discounts also something, especially if it's connected to certain thresholds. So if a client creates a turnover of a certain amount, you'll then afterwards give the client a discount either on all future works or even the discount on the work already performed. And that's one of those things you can do in jurisdictions where success fees are either not possible at all, or where success fees are only possible in very limited circumstances, and those circumstances aren't applicable in your case. But where there is the general rule that costs follow the events. In that situation, a client might, with a very strong case, might be very happy if you defer at least part of the payments or even the entire payment until the time you get judgment, and where the client then is actually awarded at least the costs which it would be awarded. Germany, for instance, that would only be the costs pursuant to the Lawyers' Remuneration Act, but that might already help for the client, and they know that they don't have to pay upfront out of their own pocket, but they can then actually pay once they get the money awarded from the other side, which then potentially has lost the case. The sharing work with the in-house team, I've not seen it as a cost arrangement. I've seen it that clients do it simply to hold costs lower, and it can be extremely helpful for the lawyers also, because a lot of the chasing, the witnesses, chasing information within the client, if that's handled by the in-house team, can be much more efficient, and it will definitely hold costs down. But I personally haven't seen it put into the fee arrangement as a component of that.
And have you noticed an increase in demand for such fee structures in your practice recently?
Interestingly, I've noticed an increase on the question whether it's possible to have a success fee. That's something which we do get, I think, a little bit more often now than a couple of years ago. Other fee structures, at least to my practice, since I've been in the practice, that has always been a topic. I hear from older partners that that wasn't the case some maybe 10 or 15 years ago, so that the new kinds of structures, also the much stronger control on costs by the companies, that's something which really picked up over the last 10 years. And that also applies for hourly rates, so it's independent from the actual fee structure. So also in hourly rates, firms are just more looking on the cost side. Corporate clients are looking more on the cost side and controlling the costs side more, and that's something which can be achieved by a number of these fee structures.
Well, that's interesting, because makes me want to ask you, Raymond, what you feel about such arrangements, possible arrangements, and notably, what do you think of the hourly rate as such? Is it an incentive for inefficiency?
Thanks, Leonard. I think the general perception is hourly rates are not desirable because there is a perception, perhaps unfairly, and I'm sure it's not justified, amongst certain companies, that the lawyers could have done perhaps the work much faster, and they were just sort of like taking a longer time to do something so that they can get more out of the engagement. But I think this issue is, or can be, easily resolved if you adopt a milestone payment system. So you don't have to touch the hourly rates, but we can have a milestone payment system such that you can charge however you want up to a certain amount, and so it's basically renders the hourly rate model sort of obsolete to a certain extent. So personally, I'm not too concerned about hourly rates.
And would you have a preference, if any, between the various structures we touched upon, i.e. flat fees, discounts, or partial deferrals?
I'm actually in favor of success fee models, basically, or what some can call a CFAs. Basically, you have a flat fee, a guaranteed flat fee for the law firms, and upon a favorable outcome, you get an additional uplift. My view on this, and perhaps it's very different from the other in-house counsel, is that I'm more focused on the outcome than the cost involved, because the cost involved is simply, to me, is simply a cost of doing business. And in this business, you know, your big, sophisticated international clients, we shouldn't really be penny pinching, if I can put it that way.
So does I see how it means, or how relevant that can be in terms of large disputes, or where the amount at stake is quite high. But what do we do when you have some smaller litigation?
I think I have to confess that I'm not so involved in smaller litigations, but I think for smaller disputes where the quantums are smaller, perhaps it can be resolved in a different way through mediation or something else. I personally would not recommend arbitration, even if the contract provides for arbitration. There has got to be a more cost-effective way of resolving smaller disputes. It's more of the bigger items that I'm more focused on.
Right, I understand. And I understand you have worked both for public entities and privately held companies. And is there any difference in terms of the approach you experienced?
Yes, there is a very big, perhaps I could say it's very, on both sides of the extremes. For private companies, especially the new emerging companies, which the tech companies perhaps, or those companies which became household names through a founder, he basically built up the company into a multi-billion-dollar company. I think they tend to be more aggressive, and they tend to be less, can I say, risk adverse. They're more open to alternative fee arrangements. On the other hand, if you move towards for example, a public, I won't say a public, more of a state-owned company, the considerations are different, and the concern is less on the actual outcome than on following the proper procedures in place. And that can actually mean that they don't really favor alternative fee arrangements, or arrangements where there could be a bit of gray areas or nuances that comes in. So, but perhaps it's not a very, very good answer, but there is a wide range, and it really depends on who the client is and who you're working with.
And what would you say, Tom? Did you notice any difference in terms of the types of clients who come up with such requests, or their business? I mean, can you differentiate between institutional clients, corporate clients, private clients, and depending on what their business model is?
I'm not sure I would say I can differentiate. I think the more sophisticated the client becomes, the more they do have professional structures in place to control costs, and the more they will want maybe a more detailed assessment of costs in advance. They might also use their bargaining power if it's a very big corporate to especially agree certain caps or discount thresholds, which also works quite well if you have a big client which gives work to the firm over a lot of different fields, that you end up with an arrangement where very high thresholds for the overall turnover of that client are agreed, which will then allow a certain reduction once that threshold is reached, which causes, I think, more problems on how to actually then distribute that discount justly between all the lawyers who have been working for that one client. But well, what I can say is that, at least in my experience, it's more the smaller and more maybe directly management run disputes where I've experienced questions of success fees in the in the last years, rather than the ones where you end up with dealing with corporate counsel, where it's, I think, much more common to look for other kinds of fee arrangements like flat fees, like caps to control costs.
All right. And is there any, the request for fee structures, we would tend to think that they mainly relate to large disputes, just as Raymond's experience showed. But have you ever come across such requests for smaller disputes, such as, I don't know, expedited disputes?
Well, first of all, the question already is, what is a smaller dispute? So if you're nevertheless talking about, of course, €1 million, it probably is, if you look for at a law firm which isn't on the scale of the law firms of the panelists right now, is still a large dispute. And I think for certain clients, these kinds of disputes are, at least for the clients, still rather large disputes. And they're, as I said, I've actually seen these kinds of requests, especially actually for success fees. If you talk about, or if you ask me about the question of whether one would agree or what would look at success fees, for instance, for an expedited proceeding or a proceeding for injunctive relief, etc., I think that's something where it's even easier as a lawyer to agree to something, because if you know that there's a limited time you can invest in a proceeding anyway, because that's what an expedited proceeding already tells you. You know that there's only a certain amount of work you can put in. And then if you've already done a couple, you can put your experience to that time and then come up with an estimate which is rather realistic. And at least in our experience, it is easier to put the right number on an expedited proceeding than it is to put it on an entire arbitration. Of course, you would nevertheless need to add certain assumptions and achieve it, so that if things don't go as planned, there's a solution for that, and you'll be able to still continue running the proceeding in an effective way for the client, and won't end up discussing with the client while the time is running away on how you will finance the further proceedings.
And what kind of caveats or assumptions will you come up with in this?
Well, I think one important, or maybe the most important one, is that you would have to define how you expect proceedings to run, because especially if you're looking at disputes which are already in the litigation phase, be it before an arbitral tribunal, be it before a state court or a mediator, you're not the only one, you and your client aren't the only ones which are influencing the proceedings. The other side can be either very cooperative or they can be very destructive in the proceedings. Arbitrators and judges can be very efficient in their handling of proceedings, they can be very inefficient. And defining certain steps, for instance, in an arbitration, defining that you expect there's only going to be an exchange of 2 briefs by each side prior to a hearing, that there's only going to be 1 hearing, that there's not going to be a bifurcation. These kinds of things are sensible to write into a arrangement if you want to end up with a cap, because otherwise you might end in a situation where the proceedings turn out to be much, much more complex and time intensive than you originally anticipated. And at the end, the client doesn't have an interest in you having a hard cap in, which will simply mean that you can't invest the time which is actually necessary, and where the client would then get bad service if they would insist on that being in place. And it makes it easier if you've already sort of put that on the table in the original agreement to then deal with these kinds of situations once they come up.
Is that something you, Raymond, would agree with?
Yes, I would agree with what Tom has just mentioned. It's very similar to what I've experienced and seen as well.
And that brings me to wondering what happens from both sides. What happens if the disputes does indeed become much more complex than anticipated? Did you experience times where it was parties, I mean, clients and counsels would speak up easily and discuss this without any real anger, or have you come across situations where there is some tension which has grown between the lawyer and the counsel and the clients? So you always wonder, being a lawyer, you always wonder what the client discloses to you and what he chooses not to disclose, as the case may be. And this can, well, take some different proportions once the arbitration has started. Maybe a huge counterclaim is raised, which you could not expect. How do you deal with those situations?
Maybe I can take this one first. I do encounter this quite a fair bit in previous arbitration matters. I think the clients can tell if the counsel is doing a good job, and to the extent that something unexpected or unforeseen pops up, I think it's fair for counsel to raise it as and when they feel comfortable. And in certain occasions, the client, I would raise it myself first and tell the counsel, do you need to charge more for this? Because at the end of the day, I think it's more of a long-term relationship, and it's more of we have to be reasonable. We are all here to make a living, so I won't have any issues. And in my experience with speaking with the board as well as the CEOs, they don't generally have an issue as long as you're able to explain to them in very simple and clear terms why there was a deviation and whether it's justified. And to the extent that you can explain that clearly, I think the senior management are generally comfortable as long as the uplift, the increase, is not, multiple times of what was initially budgeted.
Any comments?
To add on to that.
Sorry.
Maybe to add on to that, I think what Raymond just said is exactly also our experience with good corporate clients. So if you end up with a good team monitoring your case and assisting you in the case, they'll see themselves if a case gets more complex. But what it comes down to, again, is even if you don't have that, it makes a lot of sense to address these kinds of issues right at the start when you are making the fee arrangement. And also maybe to ask the in-house counsel, well, what do they need? Because we've also had clients where they have a board where the board actually doesn't like it if in-house counsel then has to go back to the board and get uplifts on the arrangements, but the board doesn't mind actually agreeing on a rather high cap at the beginning, which already takes into account a lot of these factors. And then maybe you might not end up getting your fees up to the entire cap amount, but that's not a problem for the board. So I think addressing this upfront with the client is very important. Finding out what also the internal systematics within the client are, what are the preferences of the board, what are the preferences of the legal team, and then putting a fee structure in place which is optimal for that client and that case. I think that's quite good, and that only works if you talk about it openly with the client. And of course, it's not possible with all clients, but at least with long-standing clients, I have the experience that this is very possible and very sensible.
Now, another question which crossed my mind is, when we think of fee structures, I would tend to think that the requests relating to such structures would mainly emanate from clients. Does that ever come from the lawyers themselves? Is it something you've done yourself?
Maybe that's also something which Raymond and Johan can say from their perspective. We do offer it in certain cases. For instance, as I already said at the beginning, if there's a sort of starting point where one can offer the client a flat fee, for instance, for a demand letter for the original assessment of the case, which then also allows the client to pick up from there. That's something where we do like to do it. We also often offer that one can talk about fee arrangements, and that goes to what I just said before. We don't know what is optimal for the client without having talked to the client about it. So often we say, well, we can do it on the just basic hourly rates basis, or we can talk whether there's any kind of fee arrangement that the client would prefer here. And very often, actually, clients don't come back on that, and they simply say, well, let's just go with the hourly rates, that's fine. But in other situations, they'll pick it up, and then one can find a good solution.
Thank you. So Raymond, I guess the situation may be a bit different if you have a long-standing lawyer, as opposed as the cases where you would turn to one firm for one litigation and another for another. I would not expect a lawyer to come up with the spontaneously with a suggestion that a fee structure be adopted, unless maybe the client is a long-standing client. And what do you think that makes any sense? How do you see this?
Thank you. I think to start off, we have a practice of not using a law firm or predominantly one law firm for all of our disputes or any matters in particular. We tend to rotate until we've gone through a large number of firms, simply because we don't quite believe in focusing just on one firm or a few firms. So in that regards, I am actually quite open. In a previous big dispute I mentioned, there was a US firm who came up with an alternative arrangement. Basically, well, what they did was they said, look, you know, there are two options here on the table, and this is the first time we've used that firm. And they said, you can go with the flat fee structure, or you can go with this other model, which is an alternative fee. And we're open to both options. And to a certain extent, we encourage firms to tell us their preferences. Again, because from my perspective, I'm looking at this from a more long-term perspective. And I always tell my chairman and my board, it boils down to the basics again. You have to leave something on the table for the other side so that they'll want you to be their client, because it's not just a one-sided game where we choose the firms. The good firms will also choose their clients. And we want to make sure that we have the best firms working for us, which is why I've always advocated perhaps paying them more than the usual rates, or a little bit more, so that they'll prioritize your business next time. So I think in a nutshell, I'm very open to all sorts of arrangements, and I'm flexible.
And well, would you be flexible so as to anticipate that whenever you would reach out to a law firm and ask for a preliminary assessment or budget, you be charged for the work related to that or not? I know it's a provocative question, but I can't help.
I generally would hesitate if I have to be charged for a preliminary assessment, and I know that it's fair for the firms to ask for an assessment. The main difficulty I have is convincing the CFO and the chairman of the board why we should pay for what they consider to be an informal advice or informal quotation, because in their minds, they said, you're just asking for a quote. Why do you have to be charged? Why do we have to pay for asking for a quote? And I think these battles, if I can call them battles, these battles should be avoided to the extent possible. But to be fair to the firms, I think the cost that have incurred in providing this preliminary assessment can be built in to a different part of the whole fee structure later on. So it's more a matter of timing, but they will not be shortchanged. I mean, as long as I'm handling the case, they will not be shortchanged. It's just a matter of at which stage of the recovery they'll get it, since we would normally have a milestone payment structure.
And maybe I can also ask you this question to all of you. Are there any differences between what you've come across or experienced between Asian or Chinese firms in particular, as opposed to European firms? Is the relationship as easy and smooth when it comes to discussing these topics, be it on one side or the other, or is there any difference? Are some law firms more inclined, in your experience, to agree on any types of fee structures?
Okay, perhaps I can take this one as well. I'm generally very hesitant when firms, the Asian firms, especially the newer ones, come up with certain arrangements. And the most frequent one I've come across is they will tell me that, okay, you know, if we don't win, we don't get paid. Basically, the whole story is they can do a large part of the work without getting paid. And generally, I would try to avoid these firms if I can. I would prefer to go with the European firms because you kind of know what you're getting, and you know that they are predictable. You know what you're getting. For the newer Asian firms, I think perhaps I don't know them well enough, but I would hesitate if they have arrangements that are that basically promises to do a lot of work without getting paid upfront. Because at the end of the day, again, I just want to emphasize, I'm less focused on the cost than on the outcome. And if the outcome is a good outcome and there's a reasonable chance of getting a good outcome, I'm more than willing to pay for it. And I think it's fair, I mean, from my perspective.
Thank you very much. Well, I think we have some time constraints, and unless I'm mistaken, we're running slightly behind schedule. So I would leave it there unless one of you has an additional comment to make. It doesn't seem to be the case, so thank you very much.
Thank you, Leonard, and thank you, Kitty. With just a final few minutes, I want to say some brief closing remarks. My name is Joanne Lau. I'm an arbitration partner at Allen & Overy and a co-chair of HK45 alongside Eric Ng and Ben Berry. First of all, let me start by thanking ASAb40 and Catrice on co-organizing this wonderful session with HK45. And a special shout out to Kitty, who's our HK45 committee member, and our HK45 regional ambassadors, Jörn and Tom and Luca, who couldn't make it today, but was also closely involved in the organization of this event. And of course, many thanks to both our moderators and all the speakers for sharing these views and insights from different jurisdictions, and in particular from your very diverse roles on the client side, funders, law reform committee, counsel side. I think it's particularly thought-provoking to hear about all the policy considerations that have been taken into account in coming up with these current reforms in Hong Kong. And I'm sure for users of arbitration, it's also very encouraging and in some instances very refreshing to hear lawyers spending an hour and a half talking about how to make arbitration more accessible and to make fee arrangements more flexible and more thoughtful for clients. So thank you very much for that. For those who are not members of HK45 yet, we very much hope that you will join us. Membership is free, so you can check that out from our LinkedIn page. And we very much hope to see you all again at our next event. Thank you very much.